So divorce can feel like it takes a long time. And I think one of the things that is important to know is that understanding what the likely timeline is, or at least how long certain stages tend to take, that can make divorce feel like it's taking less time because you are having more accurate expectations about how long it will take. So let's talk about things like court deadlines. Let's talk about things like statutory waiting periods. Are those the things that make a divorce take a long time in Connecticut? Well, no, that's not it. So a statutory waiting period used to be a real big thing. The concept, especially when divorce was newer in the United States, was that states wanted a bit of a cooling off period. They wanted a little bit of time, or in some cases, a lot of time, between when you start the divorce and when the court can order your divorce finalized. So that used to be a thing. In Connecticut, that statutory waiting period was 90 days. The thing that you need to know about statutory waiting periods is they almost never, at least in Connecticut, slow down a divorce. And here's why. If you have a full agreement on all issues, you can waive the statutory waiting period and go to final judgment. So for example, if you have a mediation and you're mediating your divorce and you're working outside of court, and you're reaching agreements with the help of your mediator, with the help of your review counsel, and you have a final agreement, even if it's on day one of your divorce, you can submit that to the court, request the court waive the statutory waiting period, and then you can get divorced right then. You don't have to do an additional wait. It's really important because say you aren't someone that's agreeing on your divorce. Say there are issues in the divorce. Well, if there are issues that you're having difficulty resolving or you're trying to resolve or you even need a court to decide, well, that process is going to take longer than 90 days anyway. So no matter how you slice it, even if you're super fast at reaching a full settlement, or if you have a full settlement that takes a while, or you need the court's help and a judge has to come in to help you, to help make decisions for you instead of you making decisions on your own, even in all three of those scenarios, the statutory waiting period isn't going to be what slows down your divorce. Now, discovery, on the other hand, discovery does take a while. So let's talk about what that looks like and how that can feel slow. And how I want you to feel a little bit better about the fact that it feels slow, because even though it feels slow, it's part of getting the information we need to resolve your divorce. So it's good slow. So discovery usually starts with completing your first financial affidavit and exchanging the basic background documents associated with it. So bank statements, pay stubs, information about retirement accounts and insurance, tax returns, things like that. This sort of basic financial picture of your life. That process of exchanging those basic financial documents, you have about 60 days minimum to do it. So think about two spouses. Two spouses spend time gathering that information. They remember logins they forgot. They call their financial advisor to get updated statements. There's some time and effort that both spouses are expending in order to get those documents. Then they give them to their lawyers. Their lawyers review them, learn from them, inventory them, and then the lawyers exchange that information with the other lawyer. So that's about a 60-day process, and that's assuming no one requests more time from the court. So sort of a 2-month run before you, let's say, before you see your spouse's things, about 2 months plus. That can feel slow. But the truth is that without that information, you don't have the information that you need in almost all cases to really make sound decisions. And once you get your arms around that basic information, it might lead to other questions. Sometimes no, but sometimes yes. So for example, it might share that your spouse has some complicated bonus structures at work, where say they have some options that they may not have the ability to exercise yet, but they may be able to exercise them in the future. Well, maybe you want to know more about that before you really come up with what you're thinking might be a fair way to distribute property. So maybe your lawyer recommends asking for some additional documentation. Maybe your lawyer recommends taking a deposition of someone to understand more about financials, or maybe in some cases about parenting. So there's kind of a first round of discovery that's 2 months plus, and then there can be some additional discovery as time goes on to put a finer point on things or to get information that you don't have just because of the basic documents. So discovery is long, and discovery can feel like it lasts almost the whole case because you have an ongoing duty to update things. If you happen to file for taxes in the middle of your divorce, for example, you're going to provide your lawyer with that tax return. Or if your income changes because you get a promotion at work, that's going to result in an update in your W-2 or your pay stub or in your financial background documents about your profession. Those are the things to think about. So in one way, discovery feels like it takes a long time because it kind of goes on throughout the divorce. And in the other case, it kind of feels like it takes a long time because it can feel to the client like there's a lot of activity and then there's a break while you wait for information from the other side. What's most important about this is that you know it, and that you know why we do discovery is to set up discussions about how to resolve the divorce as a whole. So without discovery, we don't get resolution. So keep your eyes on resolution and understand that discovery can feel like it happens in fits and starts. That is normal. It is okay. You're on track. So after you've done the brunt of discovery, your divorce is going to start to move into the negotiation and settlement phase. This isn't a phase like the court doesn't put this case is in negotiation and settlement on a board or anything. It's more the natural arc of a case. So after we have a lot of background information, you can start to work with your lawyer and determine, do I need any other information in order to make decisions? Or am I comfortable starting to talk about what might be a workable settlement proposal? Sometimes that's shared with the other side in a conversation between lawyers. Sometimes it's shared in a letter. Sometimes it comes out because there's a pretrial at court and you're trying to figure out if there are resolutions that you can reach while you're in court working with court staff. So this can take different forms, but generally speaking, what you want to start thinking about is what's a settlement that I would be comfortable with, that would align with my goals, and that I also think might either resolve the case, in other words, be acceptable to my spouse, or minimally wouldn't create more acrimony and have a negative effect on settlement discussions. So that's what happens. And I like to talk about this settlement negotiation phase as a concept instead of a formal thing, because even cases that get all the way to trial, settlement discussions are still happening kind of simultaneously to preparation for trial. So if you have a trial approaching, you need to be doing what you need to do to prepare for that trial, and your lawyer is going to be talking to you about that. But at the same time, if there's opportunity to resolve the case, they're going to be working on that. Or if at least there are opportunities to take issues off the table. Say you've made decisions on parenting, but you're having difficulty reaching agreements on financials, well, then you don't have to bring at a divorce trial the parenting in front of the judge. You can narrow the issues that go in front of the judge to only those that you're really unable to agree on. So that's why it's so important to think of settlement and trial preparation as a two-track process as you reach the end of your divorce and head towards trial if you haven't been able to resolve all the issues previously. So there are also external factors that can make a divorce take longer. And let's root this in litigation right now. So if you are in a divorce litigation, there are a lot of people involved. Let's talk about some of them. There's your lawyer. There's you. There's your spouse. There's their lawyer. There's the court and the court schedule, which is a big time frame issue, because if you're really needing the court and the court is very busy, it can take a while to get things scheduled. On the other hand, there can be court dates that come up a little sooner than you might want them. So that breaks both ways. The other players in a divorce that are external factors that can affect the timeline are things like perhaps you have a guardian ad litem in your case, a GAL. Perhaps you're working through some co-parenting counseling and you're interacting with your counselor's schedule and yours and your spouse's for meetings with your counselor. Maybe there's a custody evaluation happening, and so the time frame for that custody evaluation itself, combined with the schedule of all the people that are participating in it, that can impact the timeline. So there are a lot of external factors that impact the timeline of your divorce, and it's important to know when you're making decisions on how to resolve things what a likely timeline is. Example, for a GAL to do their work or a custody evaluator to conduct their evaluation, so that you just understand how long something's likely to take, because it'll impact the overall timeline of your divorce. There are no wrong decisions. It's just important to have a sense of how these things might impact the timeline. Sometimes people ask us, how long can my spouse drag this out for? So sometimes someone really doesn't want the divorce and they try to delay the process. They don't engage in settlement discussions. They're slow on turning over the documents that are required. They just sort of drag their feet. And for a while, that will work. But ultimately, what is going to happen is the court is going to come in and really actually start to push the thing forward by scheduling court dates, by no longer granting continuances if someone keeps asking for them. They're going to drive this to a head. And I like to let people know that divorce is a type of civil lawsuit. And one of the things that I think we're fortunate about in Connecticut is that in most Connecticut family courts, the timeline for a divorce is around like 12 to 18 months. Not that they don't go longer, because they do, but most divorces get to trial in about 12 to 18 months. And what that means is you can't drag it out much longer than that. And it's good to know that a normal civil lawsuit will take way longer for that 12 to 18 months. It can take much longer to get a court date if you're involved in a litigation about a contract dispute instead of about a divorce. So I like to root things in reality and make sure people know that even though your divorce could take 18 months, and that feels like a really long time, and if your spouse is really committed to dragging their feet, that'll work for a while. But at a certain point, the court is going to bring this thing to a head. So what if you're not in a litigated divorce and you don't have the court there with its deadlines, whether they're faster or slower than you would like, and you're in a mediation or collaborative divorce and you're wondering about the timeline there and if things can get dragged out? This is one of the reasons I think it's so important to meet with an attorney before you pick your process, because one of the major things that impacts the timeline of a mediation or a collaborative divorce, well, it's not the court, right? The court isn't involved. You're out of court. So the thing that impacts mediations and collaborative divorces the most is the two of you. So if you are focused on the timeline of a mediation or a collaborative divorce, first of all, know there's a ton of flexibility. You can make it faster or you can make it slower. You can make it conform with your schedules. You can do mediation sessions from the comfort of your own home in a private location via Zoom, so you're not commuting. You can structure it in a way that supports your goals for time and your general goals for how the process unfolds. But if you don't have two spouses committing to making and keeping appointments, sharing the documents, living up to the deadlines that you set for each other, right? There's no court. Making meetings, keeping meetings, being engaged in meetings, making decisions at meetings. If those things aren't happening, you're going to have a longer mediation. You're going to have a longer collaborative divorce. And in the worst case situation, ultimately, you won't reach a resolution. The process will fail because you don't have two fully engaged, committed people moving forward through the process. So one of the things to think about when you're deciding on a divorce process is whether or not you're both going to be active participants in your own mediation or collaborative divorce. And if you're both going to, not that things happen and sometimes you have to reschedule, but really, by and large, set deadlines for each other and live up to them. If you have any questions about the timeline of divorce and how it might play out in your circumstances, please give us a call and we'll work through them with you.